So thanks for the invitation to be here, and thank you for coming to this talk. I know it's not your normal computer science talk, but maybe that's part of what will be good about it. So I want to start by saying that I have been writing and doing research about computer software intellectual property protection for 30 years. I wrote a paper in 1984 which raised questions about how well copyright would do in protecting computer programs. Copyright doesn't usually protect functionality, and so putting something functional into a body of law that doesn't usually protect functional things kind of seemed like it was going to create some problems. At the same time, I wrote a paper in 1990 about patentability of software and why some of the Supreme Court decisions had decided that algorithms and other types of computer innovations were too abstract, were like mental processes that couldn't be protected. And so maybe it wasn't patentable, maybe the patent system didn't work very well, and maybe the copyright system didn't work very well. So with Mitch Kapor and a couple of other people, I wrote a paper called The Manifesto on the Legal Protection of Computer Programs in 1994, which said maybe we should have a special form of intellectual property protection tailored to the kind of thing that software is. That never took off, but at least I wrote what I thought. I've written a lot of briefs in these software IP cases, including a brief in support of Google's petition for certiorari. At least some of you may know that I write a regular column for Communications of the ACM talking about things like the Oracle v. Google case and the patentability of software. But I want to make sure that you know nobody pays me. I'm doing this completely on my own. So don't think that I'm like a Google stooge here. Okay, I fought them really hard on the Google book settlement. So I really am an independent person. So I want to start by talking a little bit, before we get into the cases that are most at issue right now, is I want to set the stage by talking a little bit more about why the existing intellectual property regimes just don't match up very well to the nature of software. That will help you understand why it is that the courts could get a little confused on some of the issues and why they are struggling to kind of reach a good conclusion on some of the very complicated issues that arise. I'll try to talk to you also about sort of what is it that Oracle is saying is going on here from a legal standpoint. What is Google saying is going on here from a legal standpoint? So some part of the value I've been trying to serve the computing professionals community is to try to translate what are lawyers talking about, because the things that may strike you as the relevant things aren't necessarily what courts are focused on. So to the extent that you have insights about how courts ought to look at these things, I want to suggest that there are ways for you to try to let that information come out. And so I'll talk about the role of amicus curiae, or friend of the court briefs, that may be worth doing if you care about this. I'll talk about what the Supreme Court is going to do, I think, and what happens if they don't take the case, and then some issues that you might want to consider. So I've already kind of indicated one of the problems with copyright for computer programs is copyright protects artistic and literary works, right? Things that are only functional insofar as they convey information or display an appearance. The functionality of most types of works excludes them entirely from copyright in the US system. And so source code fits pretty well in the literary work category, where literary work just is a work consisting of symbols. words or symbols. But of course, object code is a functional process, and that's something that copyright doesn't usually do, but Congress said, oh, well, let's do it anyway. And then the question is, what happens? So clearly, the copying exactly bit for bit of programs is going to be infringement. There are things, there's sometimes expressive, conventionally expressive elements of, for example, video games, right? The sort of the colors and the movement and the songs and stuff like that. All of that stuff is kind of conventionally like a kind of audiovisual work, and so so some cases have involved copying video game graphics and the like. But the question that has bedeviled the courts for the last 25 years or so is, to what extent are non-literal elements of computer programs eligible for protection by copyright law? So a non-literal element of a program might be an algorithm, might be a data structure, might be the API, might be any one of a number of things. You know this better than me, but part of what we're trying to sort of figure out is what structural features of computer programs are expressive in a copyright sense and what ones aren't. And command structures of user interfaces and APIs have been two of the places where there's been quite a bit of litigation, although it died down for a while. So I've talked now about why the software is a misfit in terms of the copyright system. Let me say a few more things about why it's a misfit with patents. So software is a technology, right? It's a virtual machine. If machines are patentable, then virtual machines should be patentable, right? This sounds really like logical. The problem has been that in respect of programs as writings, right, the literary work metaphor, well, there's a doctrine in patent law that says printed matter can't be protected by the patent system. And so most works of literature, for example, would flunk any effort to patent them by saying it's a printed matter, blah, blah, blah. And when the patent office first was presented with programs, the patent office said, looks like printed matter to me, and so flushed those out of the system. But of course, even if you got a patent on a particular program, it would be pretty easy to rewrite it. So in fact, what people try to patent are things that are more abstract elements of programs. But the question about whether or not those more abstract elements are patentable subject matter is something that the Supreme Court did a lot of work on in the 1970s, calling into question the patentability of algorithms and other processes that may be implemented in computer code, but in fact are mental processes, step by step by step kind of things. So mental processes and abstract ideas are patent doctrines that flush out a lot of the elements of programs from the patent system. And the Alice versus CLS Bank case, which the Supreme Court decided last June, is a decision that seems to call into question a lot of software patents. And so those of us who are watching what's going on in the software patent arena are seeing courts strike them down one after the other. So it's not all of them have gotten struck down, but I would say something in the neighborhood of 90 to 95% of the software patents that have been litigated lately are patents that are getting flushed out of the system as not patentable subject matter either. So we have then this kind of contextual situation where there's a lot of value in computer programs, but copyright doesn't seem very well suited to it, and patents don't seem very well suited to it. So what do we do about that? So that's kind of the background. So another thing that actually makes this all complicated is this notion that there's kind of like writings of authors over here, and that's the job of copyright. And machines, manufacturers, other technologies over here, and inventors of those novel and non-obvious machines get patents. But it seems like, right, they're like two different universes, right? There's copyright over here. Copyright attaches automatically by operation of law. You don't have to apply as you do for a patent. It lasts a really long time, 95 years for corporate authored works, and patents, if you can get them, will last no more than 20 years, but you have to apply for them and you have to sort of satisfy all these requirements in order to get them. So you can see that there's a little bit of temptation out there to try to extend copyright protection to things that probably ought to belong in the patent system. And because if you don't apply for a patent, then your innovation, once it becomes known, is in the public domain and free for everybody to use. And so I put up the Constitution here because you can see that you can see built into it this notion that there's these two separate universes, right? Writings of authors that promote the progress of science and inventions in the useful arts, and this kind of word respective, again, signals that these two things are completely different. Okay. So I've pretty much already covered this. So there's a case that was decided in 1880. It turns out this case is like the battleground right now on the issues that we're concerning ourselves with. So let me talk about it a little bit, because people have different interpretations about what this case means, and I have a very distinct position on this, and other people have a very distinct position on it. So it turns out to be pretty important. So Charles Selden came up with what he thought was a brilliant idea for a new bookkeeping system, and so he put together a set of forms that would implement the system and wrote a little explanatory text to begin with and published that as a book. Then Baker, also a bookkeeper, decides to write his own book and included in that book forms that were substantially similar to the forms in the Selden book. And so Selden's widow sued Baker for copyright infringement, claiming not only copyright protection in the book, and that the scope of copyright in that book extended to the system that was being implemented through the forms, but also copyright in the system itself, right? So if you kind of think about what a bookkeeping form looks like, it's got columns and it's got little headings, and so the particular selection and arrangement of the columns and the headings were thought by Mrs. Selden to be part of the book that was important commercially, and therefore when Baker came along and stole the forms, he should be punished as an infringer, and also that anybody who was using Baker's forms was an infringer too. This turned out to be significant because there were 40 counties in Ohio that were using the Baker forms, and so the liability not only of Baker but also of all the people who were using the system was kind of at stake, and so it's a pretty important thing. So a trial judge in the late 1860s ruled in favor of Selden, and Baker appealed. So the Supreme Court, in actually quite readable decision — not many of the Supreme Court decisions are readable, but this one is — but the court said, look, Selden's copyright in the book extends to his explanation of the bookkeeping system, but not to the bookkeeping system itself. And the court seemed to perceive the selection and arrangement of the forms, the headings and columns and so forth, as implementations of the system, and anybody was free, the Supreme Court said, to to copy the bookkeeping system and make their own forms to do the same kind of work. And the court spoke of the bookkeeping system as a useful art, which you couldn't get protection from copyright for. That's only the explanation, or today we use the word expression. But part of what caused the court to kind of raise the issue about useful arts was that in the preface to Selden's book, he talked about having gone to the patent office and tried to get a patent on his wonderful invention. Well, the guy who wrote the opinion for the Supreme Court basically said, he's a patent lawyer. He says, you're trying to get a patent, the patent office didn't give you, right? Obviously, if you're suing for copyright infringement, you didn't get the patent that you tried to apply for. And so the Supreme Court said, you can't do that, right? So copyright then has the role of protecting explanation, description, and the like, but not the systems that might be described therein. Yes?
What did the patent office do?
We don't know.
Because
it's not in the record.
Because if he was turned down for this isn't patentable, then that would seem to be, hey, just because I claim something's a banana, if the government says it's not.
It may very well be that the patent office rejected the patent on subject matter grounds, as I think the Supreme Court would do today if a bookkeeping system was before it. However, I know from having read the brief submitted by Baker's lawyer to the Supreme Court that one of the things that the lawyers argued was that if there's a gap between the patent system and the copyright system so that something like a bookkeeping system isn't eligible for either, that's a matter for Congress, right? If Congress thinks that things like bookkeeping systems need some legal protection, it's up to Congress to do that, but that's actually not the tack that the Supreme Court took in Baker v. Selden. Instead, the court accepted that this might be patent subject matter and basically said, it's a useful art. If you're going to get protection for that at all, you got to get a patent on it. You can't use copyright in order to do it. And you see there's the temptation again to stretch copyright to reach something that's valuable is something that's very appealing. And again, we see that in some of the things that we some of the issues in the Oracle v. Google case. So the court says it would be a surprise and a fraud on the public if we allowed people to get patent-like protection for something that's ineligible for patent protection, and you can't get that from copyright. So again, this case kind of reinforces that categorical exclusivity thing that I talked about before, right? Writings over here, machines over here, never the twain shall meet except when computer programs come along and mess everything up. So the current kind of battleground is based on the Copyright Act of 1976. That statute in the most relevant part says that copyright subsists in original works of authorship that have been fixed in a tangible medium of expression. So once you make source code, transform it into object code, that's the literary work that copyright subsists in. But Section 102B is a really interesting provision. It says that in no case does copyright for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of how it's embodied in the work. Yeah.
I'm wondering, in this sort of functional versus writing distinction, is there anything from the history of like player piano rolls or loom, mechanical loom instructions that gives a useful perspective here?
No. The answer is the looms were never copyright subject matter, so that didn't come out. Now, if you in fact make an original design with a weaving, the kind of the pictorial elements of the weaving could be protected by copyright, but not the
punch card that embodies the design.
It never came up. Okay, now piano rolls actually did come up, but here's what happened with that. So it was not the case that the piano rolls themselves were claimed copyright protection in, but rather there was a case in about the turn of the century, the last one, where somebody was making piano rolls of popular music, and the question was whether or not the piano roll was an infringement of the musical composition. Supreme Court decides you can't read it. So you can't read it, right? So because remember, like what does what do most works of authorship do? You can see them, right? So in this case, the Supreme Court said musical composition is defined in terms of notes on paper. This isn't notes on paper. And so decided that that was not an infringement. The next year, Congress passed an amendment to the copyright statute extending protection to musical works so that mechanical reproductions were, so the sound recording people had to pay the musicians for that. But it wasn't until 1971 that Congress passed a law extending protection to sound recordings. So that is another chapter, but it's a very good question, so thank you for that. But this question that I'm interested in, and that is at the heart of the debate that we'll be talking about, is what do these process, procedure, system, method of operation words mean? Now, the legislative history of this provision indicates that Congress was very express. They added it to the statute in order that computer program copyrights would not be too broad. Didn't say what it meant. And unfortunately, the group of people who studied computer program copyright issues did not include a single person with any technical training whatsoever. So you have a group of people who didn't know what they were talking about, writing a thing and said, well, it's a literary work. It's going to be easy to apply copyright to. It's like, yeah, right. Anyway, so the other concept that actually I should mention is what is this concept called a merger of idea and expression. So a fundamental part of copyright law, not only in the US but in the world, is that copyright only extends to the author's expression and not to the ideas. But there are occasionally situations in which there are just not very many ways to say something or to do something, to depict something. And in that case, idea and expression merge. And if they merge, then there's no protection for the merged entity. It's only, maybe there'll be something else that can be protected, but not that merged element. Okay, so the two main positions are that Section 102B means nothing more than abstract ideas are unprotectable. This strikes me as a specious interpretation of a statute that has 8 words of exclusion, and essentially sometimes the courts read those other 7 phrases out of the statute, and so it has been my lifelong challenge to try to get the courts to basically pay attention to those words. The question also about whether merger is something that only can apply, merger doctrine can only apply when at the very beginning of the plaintiff's creation process, there wasn't any other way to do it. So there's a debate about whether or not merger can happen, for example, over time, or whether some things, even if they were creative from the get-go, in fact constrain the design decisions of later people so that it shouldn't be protected at all. So that's kind of just setting this up. I swear to God, the next slide I'm going to get to Oracle v. Google. Oh, well, never mind. Well,
it would seem from that last bullet on the previous slide that a cookbook is not protectable.
No, recipes aren't protectable. But a creative selection and arrangement of recipes my favorite chocolate cake, my favorite lemon cake, and so forth. Those things can be that the cookbook as a compilation can be protected, but none of the recipes can be.
Free to copy the
Yes,
recipes and put them
exactly,
around.
exactly, and rearrange them in a different compilation, right? So that's the rule about that. Okay, so let me talk about what happened in the Oracle v. Google case. So Oracle sued Google in 2010, shortly after taking over Sun Microsystems, and the allegation, so there were patent claims in the case, and I think Oracle initially thought it was going to win in the patent claims, but a jury ruled against the patent claims, so all they have left in the case is these copyright claims. The claim at the trial court level was that Google had copied the structure, sequence, and organization (SSO) of the Java 37 of the Java API packages. And in 2012, the district court decided that those 37 Java APIs were not protectable by copyright law. And this is kind of the nub of what the rationale was. The SSO of the Java APIs were, in its view, a command structure, and that command structure was a method of operating a computer in order to achieve certain results. The court also adopted the notion of idea expression merger, saying that the rules of Java syntax dictate, and certain names have to be identical or things won't interoperate. And so there was a merger of idea and expression. And the court accepted and made findings, actually, about Google having used those Java APIs so that Java apps could run on Android, so that you needed them for compatibility purposes. This is important because there's some prior cases involving compatibility type of issues. And so APIs have been treated in some other cases as unprotectable elements of computer programs. But the trial judge also noted that Java programmers expected to be able to use those names and commands and Java API specifications if they were writing apps for the Android platform. So the Court of Appeals for the Federal Circuit last year decided that that Oracle was right and Google was wrong, and this is the core part of what the court had to say on these issues. So there was no merger of idea and expression in this case, because at the time that Sun's engineers designed the Java APIs in the first place, they had lots of choices about names, they had lots of choices about how to structure things, and so that creativity was enough originality to make the API's protectable expression not merged, and so also the court really says that if there's only one way to do something, then that's the situation of merger. And there were at least 3 of the Java packages that even the Court of Appeals thought you can hardly do anything in the Java language without those 3 core packages. So maybe those core packages would be something where there was merger. But everything else, Google had a chance to do things differently, and it chose to copy and free ride on the value that Sun, now Oracle, was the owner of the intellectual property rights in. So remember the trial judge said that the Java API headers for methods and also the classes were a command structure that was a method of operation excluded from protection under 102B. The Court of Appeals says that what 102B is about is the unprotectability of abstract ideas, and because these Java APIs are specific and concrete, right? They look like words and symbols, that they in fact there was no, they weren't method of operation, they weren't excluded from protection, and made the claim that Google's argument was really trying to undermine copyright protection for computer programs altogether and throw everything over into the patent bin. And the court said, can't do that. The court said there's no interoperability or no compatibility exception to copyright protection. So Google may be able to raise interoperability issues when the case goes back down to the trial court for further proceedings under a fair use defense, but it's not relevant at all to the copyrightability of the Java APIs to begin with. So that's the core stuff. A couple of other things that the court did that are important. So at the trial court level, the case was litigated as what I call a SSO case, right? The structure, sequence, and organization of the Java APIs. There wasn't a claim of any literal copying of code. The appellate lawyer that wrote the brief to the Federal Circuit decided to go whole hog and say that the method headers, in fact, are lines of code, and so 7,000 lines of code were stolen by Google, so not only that, but they copied the SSO of the Java classes, and so all of this is just terrible, terrible, terrible. I think the Federal Circuit was affected by the argument in Oracle's brief that, look, they negotiated for a license, so they knew that they needed a license. And then when they didn't get the deal that they wanted, they decided to copy it anyway. And so blah, blah, blah. So the failed negotiations with Sun is something that tainted the view of the Federal Circuit on this particular issue. And even more damning from the standpoint of the Federal Circuit was the notion that Google, by copying 37 of the Java APIs and not the whole set, had actually designed it to be incompatible with Java, and that was another thing. So this, oh, I'm trying to be interoperable, oh, I'm trying to be compatible, is a bunch of hooey from the standpoint of the Federal Circuit, who thinks that basically, you designed it to be incompatible, so you can't raise compatibility defenses if, in fact, you designed it for this purpose. And one thing that actually the trial court had said was that Java APIs that he was hearing about and was ruling about looked to him more like patent subject matter than copyright subject matter. And the judge noted that actually both Sun and Oracle had gotten patents on APIs, which sort of made it seem like it was patent subject matter. So to the extent that Oracle was claiming copyright in it, right, the old Baker v. Selden approach would say, oh, if it's patent subject matter, then it can't be protected by copyright. It's kind of two different worlds and two different regimes. But the Federal Circuit said, well, it doesn't matter if they're patentable and copyrightable, as nobody says that you can't get both. Well, actually, the Supreme Court does, but who's counting? So Google has asked the Supreme Court to review the Federal Circuit's ruling, and the main arguments that it's making is that this case is one of exceptional importance to the software industry. There's a conflict among the circuits, and so there are decisions. We live in the Ninth Circuit. There are decisions from the Third Circuit and from the Federal Circuit that are at odds with decisions in the Ninth Circuit and the Second Circuit. And so one of the ways and one of the reasons the Supreme Court takes cases from time to time is because the law is supposed to be uniform throughout the United States of America. You can't have kind of the patent law interpreted this way in California and this way in New York. You basically have one uniform law. So the the conflict of the circuits is as to the interpretation of this Section 102B, especially the process, procedure, system, method of operation exclusion, and the interpretation of the merger doctrine, the significance of interoperability, and whether or not APIs are really more patent subject matter than copyright subject matter. It just so happens that the interpretation of Section 102B was an issue that was before the Supreme Court 20 years ago, and they split 4-4 in the Lotus v. Borland case. And so the kind of what does 102B mean has been kind of hanging out there for 20 years. And so one of the reasons why the Supreme Court may take the case is, in fact, that they punted, right? They kicked the can down the road, and now the can's coming back to visit them. And there were several amicus briefs in support of Google's petition. So Oracle, of course, says no need to take this case. The argument that they start with is the notion that what Google did is copy source code, and there's no circuit split about the copyrightability of source code, so you don't need to take it. There may be some circuit splits on other aspects of this, but not about source code. Of course, Oracle thinks that the Federal Circuit correctly interpreted Section 102B in the merger doctrine. The court said, Google can make a fair use defense and raise stuff, but Oracle says, look, this is not ripe for Supreme Court review, because usually if there's an issue that's still pending in the case, you send it back to the lower court to have further proceedings, blah, 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 and then final judgment, you appeal that, and they respond to the patent copyright subject matter issue saying, no problem to have it be both patentable and copyrightable, big deal. So there were seven amicus curiae, friend of the court briefs. So the Electronic Frontier Foundation organized one for 77 computer scientists. So if you want to follow through at some point, you don't like this decision either, talk to EFF. Public interest firm based in DC, Public Knowledge, filed a brief. Hewlett-Packard, Red Hat, and Yahoo did, and these other people, and me too. The one amicus brief that was filed in support of Oracle's deny cert was the Free Software Foundation. You kind of go, what? Here's the thing. They're afraid. Eben Moglen's afraid of what the Supreme Court will do with this issue, because they couldn't even figure out Lotus v. Borland, and Lotus v. Borland was a pretty simple case. So they're worried that the Supreme Court could really screw things up bad. So Supreme Court. The Supreme Court doesn't have to take cases, as I'm sure you know. So sometimes the Supreme Court asks the Solicitor General, that's the kind of chief legal officer that files briefs with the Supreme Court, to review the case and make a recommendation about whether the Supreme Court should take it. So one of the data points that I saw is that if the Supreme Court asks the SG to take to review the case, that makes it 46 times more likely that the court will take it than if they don't refer it to the SG. They have three options, right? One is to ask the SG, one is just to deny it outright, and one is to say, okay, we're going to take it. And what is certiorari? Certiorari is a writ, a document, old legal term. It means bring the record forward. So if the Supreme Court issues a writ of certiorari, they're issuing an order to the appellate court to bring the whole record forward so that the Supreme Court can go through the whole thing. Anyway, if the Supreme Court takes it, which we'll probably know by June, if they take it, it will be heard next fall. So what happens if the Supreme Court denies cert? Well, what happens is the case will be remanded to have further proceedings about the fair use defense, and Google came within one vote of a fair use ruling to a jury back years ago. The Federal Circuit decision is not really going to bind any other circuit because it doesn't usually hear copyright cases. The only reason it heard the copyright case in this particular situation is because there was a patent claim in the case at the beginning. So usually copyright cases would go to the Ninth Circuit, and the Ninth Circuit case law on APIs is actually not consistent with what the Federal Circuit did, but whatever. But what you're going to see is some litigation, right? If the Supreme Court denies cert, then that will mean there'll be a lot more lawsuits about command structures, APIs, and the like. And so it'll call into question these decisions from 20 years ago that seemed to say that APIs are not protectable. So I think they'll take the case, and I predict they're going to reverse. But you never know. So how do courts decide things like this? Well, they look at the statute and they try to interpret the statute. They look at the legislative history if the statute isn't exactly clear. They look at the prior case law. And then they engage in a kind of pattern matching exercise, and then try to think about what impact is this going to have on third parties. That's one of the reasons why amicus curiae briefs are really important in Supreme Court cases, because it gives an opportunity for people who don't have the skin directly in the game, right? They're not parties to the litigation, but boy, this is going to have big impact on me, this other guy, and this other guy, and so take that into account, Supreme Court, when you make your ruling. Yeah.
Has the Solicitor General spoken?
No. Takes two to 3 months. So the Supreme Court asked the SG to look at it on January 12th. I know this exact date. And so it's going to take 2 to 3 months. So we'll know something, I would say, late March to late April timeframe.
Who is the Solicitor General, and which way do they have a thumb on the scale, if any?
So Donald Verrilli is actually the Solicitor General of the United States. He's a very good lawyer. He won the MGM versus Grokster case before the Supreme Court. So he's been known, shall I say, to take the entertainment industry position on certain things. But that's, he was a lawyer representing blah, blah, blah. So, don't... It's just interesting information. I don't know that the motion picture industry has any skin in this particular game, but of course they care a lot about what the Supreme Court says about copyright law, so they might weigh in some respect or another.
And does the administration otherwise weigh in?
No, there is part of the reason it takes a couple of 2 to 3 months to get the SG's brief happening is that there's an intergovernmental consultation. So people in the White House, people in the Justice Department, people in this department, people in that, OSTP can weigh in. So there's this kind of intergovernmental consultation, and then the Solicitor General's office, after having consulted with everybody, essentially makes the best judgment on behalf of the administration for that.
That's a good thing.
The connections between video games and comic books and movies seems to suggest that there might be some interest on the part of the entertainment industry in the outcomes of this.
Yeah, but this is not a video game case, right? I mean, it's not even close to a video game case. I just don't think they care that much, but I could be wrong. They haven't weighed in so far. Okay, so again, part of this pattern matching thing is sort of let's talk about sort of the chief cases on which Oracle relies, and then the chief cases that Google's relying on, just so you can kind of see a little bit of what that pattern matching looks like. So there's a case in 1986 called Wayland versus Jaslow, where a guy who wrote a dental laboratory program was alleged to infringe by copying the structure, sequence, and organization of certain elements of the program, some file and data structures, and some ways that certain subroutines operated. And the Third Circuit Court of Appeals, which is kind of New Jersey Pennsylvania based, made this analogy that software is a literary work. Copyright protects the structure, sequence, and organization of literary works, and so it should protect the SSO of computer programs too. And there's merger of idea and expression only if there's no other way to perform a function. And since there were other data structures and other file structures and other ways you could have organized the subroutine, then that copying was copying of part of the expression of the program. And the Third Circuit also said, if we don't give strong protection to computer programs, the industry will fall apart, and that would be terrible. There's also a case called American Dental Association versus Delta Dental, and what happened in this case is the American Dental Association had developed a coding system, ding, ding, ding. It should have rung some bells in 102B land, but the judge decided that the standard names that the ADA had come up with for dental procedures and associated that with a number. Right, so this tooth has a certain number, and if you have too many cavity on this side, it's one number. Cavity on that side, it's a different number. And basically, the coding system was developed to facilitate insurance sort of processing of claims. So Delta copied not any of the text, not any of the explanation in the ADA book, but copied the taxonomy of names of the dental procedures and the numbers representing the names, and then had its own guide that it was making available to dentists too. ADA sued Delta Dental, and the Seventh Circuit Court of Appeals in 1997 said that the names of the dental procedures and the numbers were copyrightable because there were a number of different ways you could do it, and so there's no merger of idea expression, and it's not the kind of system that is ineligible for protection under Section 102B. So that's their cases. The main case that the trial judge relied on is this Lotus versus Borland case that came down in 1994 from the First Circuit Court of Appeals, which is based in Boston. So Borland had developed its own spreadsheet program to compete with Lotus 123, and it had a native interface for those people who were starting with from scratch using a spreadsheet program. But in order to woo over to the Borland program, some people who had been familiar with Lotus 123 and had constructed macros in the macro command language that Lotus made available to its customers, decided to for that emulation interface, the exact same commands had to be in exactly the same order in order for the emulation interface for the macros to execute properly. So the district court said there's creativity in the selection and arrangement. Instead of copy, you could have used replicate, or you could have used this word, or you could have used that word. For paste, you could have used this word or that word, whatever. So because there were lots of alternatives, there was no merger of idea and expression, and the Section 102B is really only about the unprotectability of abstract ideas. The First Circuit Court of Appeals reversed and said that the command hierarchy, the structure, sequence, and organization of the commands for Lotus 123 commands in the emulation interface, that was an unprotectable method of operation excluded from protection under 102B, and the court likened the commands to the buttons on a VCR. So you press this one, and it's a method of operating the VCR to do this function and that function. So that analogy of you press that command and it does this function, right, seemed like a strong argument. And so the court decided that actually that was an unprotectable method of operation. The Supreme Court heard oral argument in the case. Justice Stevens, unfortunately, recused himself, I think because he owned some IBM stock, and IBM owned Lotus at the time. So they just said, we can't decide this because we're split 4-4, and so the issue has been kind of hanging on. There are two other cases that are actually relevant, and I'm sorry I'm talking a lot. I hope this is packed. There are two other cases that are worth mentioning because these are the cases that involve interoperability issues, right? So the Second Circuit Court of Appeals, which is the one based in New York and actually is very influential, generally speaking, in copyright cases, was faced with a case where Altai and Computer Associates both made scheduling programs that would interoperate with IBM system operating systems, and so they both had compatibility components to their software, and there were structural similarities in the list of services and in the parameter lists of the two programs, and the question was whether or not those structural similarities would give rise to infringement, and the court decided not, that there was no infringement because Computer Associates and Altai were both constrained in their design decisions about how they structured the compatibility component because of the constraints from the programs that they had to interoperate with. So this is a place where they didn't use the word interface, they didn't use the word API, but the language that the court used was to say that when you are constrained in your design decisions, that you can't do something any other way, and you want to be compatible with somebody else, then it's okay to copy that which is necessary to achieving interoperability. And so that was then the kind of the decision in 1992 that kind of set the standard. It criticized that Wayland versus Jaslow case, among other things, for its inaccurate understanding of computer science. And the court basically said the other court was completely wrong. And so in the 20-some years after the Altai decision, everybody but the Third Circuit follows the Altai case. And the important case in the Ninth Circuit is the case called Sega versus Accolade. So Accolade made video games, and most of those video games ran on a PC platform because the Sega Genesis platform was really popular, and there were lots and lots and lots of things out there. They wanted to be able to adapt their games so that they could run on the Sega platform. Accolade acquired copies of the software in the machine and in the video game and reverse engineered them in order to extract the information necessary to then re-implement in independently written code for the Genesis version of the Accolade games. Now, this didn't come up to the courts as saying that the API that was embedded in the program was protectable by copyright law. That wasn't what was being argued at all in the case, but rather Sega was arguing that because the process of reverse engineering the code in order to extract the information about the interface was copying of a computer program, that it was infringement. It was infringement just to reverse engineer. And the Ninth Circuit said, oh, baloney to that, said that it was a fair use to make copies for reverse engineering purposes when you were trying to extract information necessary to achieve interoperability. And in that case, the court spoke of the interface for the Sega programs as unprotectable procedures under Section 102B. A few years later, the Ninth Circuit in another case reaffirmed its ruling in the Sega v. Accolade case, again talking about the interface as an unprotectable procedure under Section 102B. Now, the Federal Circuit is supposed to follow Ninth Circuit precedent when it reviews cases, because it doesn't have any jurisdiction over copyrights, it has jurisdiction over patents, but occasionally they get a copyright case. But when they get a copyright case, they're supposed to follow the circuit rulings, and so the Federal Circuit decided that Sega v. Accolade case didn't say what it said, and so that's one of the reasons they should get reversed. And so that's, anyway, this is another one of the cases that Google is relying on. Okay, so I mean, the big picture issues are ones that are probably more salient to you than all the stuff I've been talking about, but you kind of look at the big picture. Is the Supreme Court going to look at the big picture? I think they know this is a pretty big deal, and part of actually what's important about this case is that the rationale that the Federal Circuit used in rejecting Google's defense calls into question all of the interoperability rulings that have been out there for the last couple of decades. So it's important to sort of understand that this can of worms had been kind of closed for a while, and this case is kind of reopening it. And I'm like going deja vu all over again. I've written briefs like this before. But of course, the issues are not easy, partly because, right, we put computer programs into copyright law without really anybody from the computing community having anything to say about what the scope of protection should be. And so, you look at something like the method headers and the method specifications of Java, and you sort of say, boy, it looks a little more like copyright subject matter than it looks like patent subject matter. I think this was also one of the problems that the Supreme Court had in the Lotus v. Borland case. So if you look at those commands, the user interface commands of Lotus 123, it's like selection and arrangement of words. Looks like copyright to me. And the court, some members of the court couldn't see that the selection and arrangement of those commands wasn't just, oh, I'm just going to be creative today. It was a fundamental part of the functionality of the Lotus macro system. And because of that, it should have been outside of the scope of copyright protection. That's what I wrote to the First Circuit. That's what I wrote to the Supreme Court way back when, and it didn't take. So, I'm going to try to bat again and see whether I can win this one.
Did the Google lawyers make a fundamental mistake in saying that it was code? It's just interface files. They actually don't perform any functionality.
So this is the thing, okay? So Oracle has a really good lawyer. He's one of the best lawyers in the country. And he changed the nature of the conversation. So what I mean by that is that when the case was tried, before the trial court says, and this is actually a finding of fact below, is that there was no copying of code. That Google re-implemented everything in independently written code, and so there's no copying of code. It's a structure, sequence, and organization case, right? They re-implemented the specification, the commands in different code. But by the time the case went to the Court of Appeals, they got a different lawyer. Different lawyer says, "Hey, I see these words in the source code. Let's make this into a literal copying case." Now, usually, courts don't let you do that, right? So if you argued one thing down here and you didn't win, you can't sort of say, oh, well, let me kind of re-characterize what the facts are. But in this case, not only did Josh Rosencrantz do it, but he succeeded at it. And that's what...
Those objections.
Yes.
Okay.
But the Federal Circuit, they're the judges, okay? They get to issue the rulings, whether you like it or not. So one of the things that Google is going to have to, if the Supreme Court takes it, Google's going to have to be very, very sharp to distinguish between the method headers, which are not executable code, and executable code. That's actually, they did that, all right? Oracle didn't even argue literal copying at the trial court level. They only argued it at the appellate court level.
The second point, though, is sort of interesting because I can disclaim patent protection. I can invent something and put it into the public domain. And is that even possible with respect to copyright?
So this is interesting. Yeah, you can, but you would then have to disclaim it altogether. You have to abandon your claim of copyright. And so, this is one of those things where if you say to everybody, oh, please implement this, oh, please, write your own code, yay, we don't stand for copyright protection for APIs, we don't stand for patents, although they got some anyway, but whatever.
That seems to be line 2 of Sun saying, no, please, we don't stand for copyright
Well, so
protection.
the thing is that they did that in every public forum. Back in the 1980s and early 90s, they filed briefs in the Altai case and in the Lotus v. Borland case, so they were active players. But of course, just because somebody owned an asset once and said, oh, come play on my backyard all the time, and then they sell the house and somebody else buys it, they say, no, you can't come and use a swing set anymore, right? It's like the question of whether or not Sun can be bound, right, or the Oracle can be bound by statements that Sun might have made about this, it's not clear. It's not going to be one of the top things, but I'm sure that peppered throughout at least some of the amicus curiae briefs are going to be statements about, hey, Sun used to say X, Y, and Z, and Sun used to say X, Y, and Z, and some.
The question is, can you act?
You can't bind Oracle to it as far as I know.
The question was, is this a fundamental feature of copyright law that you cannot throw something in the public domain?
No, you can't, but you have to do it more expressly. You can't just go into. So they did. Okay. What they would say is that copyright protection for APIs is really a bad idea.
But if they had said copyright protection for the Java APIs, no, we don't want it.
Yeah, that would have gotten you closer to it. But anyway, the point is that's probably not going to be something that's going to win the case. Part of what, of course, the courts have to deal with is the statute and the case law. And, they can do some big picture stuff, but, one of the questions that, that is kind of out there is if you have all these Java programmers who know how essentially to speak in Java by implementing these APIs, do they have to learn everything from scratch in order to write for the Android platform? That's, essentially that's what Oracle is arguing, is that they should have made up entirely their own APIs and not used any of the Java ones. Yes.
In the early days of Java, there was a dispute between Sun and Microsoft because Microsoft had changed some implementations, not the API, but they were doing slightly different things. I don't remember the details or how that came out. Is that relevant?
So, yes and no. It's not relevant to the copyright issues in this case because the context within which that dispute was being part of the kind of antitrust claim that was being made against Microsoft by the Department of Justice mostly. the claim that Sun was making at that time was not about copyright, was not about intellectual property so much as saying that by forking, by fragmenting, by essentially not making things fully fully compatible, that they were actually, it was another strategy to monopolize the software market. So it was a different legal context than the case that we're talking about today. Yeah.
Is the argument that something like this does not promote the progress of science and useful art, is that argument gaining any traction?
Because it's John.
Yeah, it'll be a lot of what's going to get argued. So pretty much every brief will say, "Well, promote the progress of science and useful arts better if you rule my way." And so part of actually what the court has to deal with is these kind of self-interested statements, right? So Google want to say, "Oh, well, startups are really going to be hurt by this," and then the Supreme Court say, "Yeah, right. You care about that a lot, I know." So that's why amicus curiae briefs actually then provide an opportunity for the court to get some, not completely disinterested, obviously, but at least some feedback. So if in fact there are startup companies and organizations that represent startup companies who file an amicus curiae brief in support of Google's claim, then Google's brief, when it says, "Oh, well, this is really gonna have a bad impact on startups," then it actually will be much more plausible than if they do the other thing. So what'll happen actually, and a lot of what the sort of interesting stuff that, at least for somebody like me, is what's going to happen when it comes to who is Oracle going to try to line up as amicus curiae in support of them, right? Because they're not. So, Microsoft will be their friend then on that one. But who else will be, who else? So they'll be around trying to get, they'll probably try to get some computer scientists to file on the other side to kind of offset the kind of 77 that EFF rounded up.
What's the connection with this and instruction set APIs, the AMDAL or the Intel x86?
Yeah. So here's the thing. The case law is not entirely clear, and I think the literature more generally isn't entirely clear about whether all APIs should be treated the same or whether some APIs might be protectable and some might not be. Okay, so what we have in, let's say, the Sega versus Accolade case is an example of something where Accolade reverse engineered, it extracted certain information, it then re-implemented it in code that then allowed their games to work on that platform. That's a very specific interface, and different cases involve different kinds of interfaces, and it isn't clear that all APIs should be treated the same. What is clear that is at least some of the cases have ruled that interface procedures that are necessary for interoperability are unprotectable elements of computer programs. And there's one case also where a company called Connectix made an emulation software platform so that people who had Sony PlayStation games could play those games on the Connectix emulation platform. And they were not fully compatible with all the PlayStation stuff. They were only compatible with so much and blah, blah, blah. There's another case, involving Nintendo and Atari games. And this is like different kinds of interoperability situations have been presented before. But it's not like there's kind of like complete consistency. So, in Europe, they more directly, as a kind of a statutory matter, thought about interfaces, and instead of saying, as a lot of people wanted them to say, that interfaces aren't protectable by copyright law, They say, insofar as interfaces are ideas or principles, they are unprotectable by copyright law, leaving to the courts the decision about in what circumstances are those interfaces protectable by copyright law or not. So it opened the door to a fight about this particular thing. But again, there's been a lot of litigation on these issues in the United States, but it kind of calmed down, right? There was like its time from about 1986 when the Wayland versus Jaslow came down to 1992. There was like huge storms of litigation and big fights. I gave talks at a lot of technical conferences during that time to try to help people kind of understand what was really going on. But after the Altai decision came down, and the Altai decision sort of said some things, that basically propagated out, and so things calmed down. And now the Federal Circuit's ruling is opening things up again for further complications.
Is there any sort of statute of limitations on this, or in a sense, I remember that one of the things with copyright law, if you're aware of an infringement, you can't just let it stand. And so, Sun's behavior, Oracle sort of reversing Sun's behavior seems like, to a certain extent, a bait and switch.
So there is a statute of limitations of 3 years. You have to bring a claim of copyright infringement within 3 years. Unfortunately, I think Google would have loved to get out of this case on a statute of limitations ground. There's another kind of doctrine called estoppel, and another kind of doctrine called latches. So latches is like if you wait and wait and wait and wait, and then suddenly, somebody makes $1 gazillion off something, and then you say, well, now I'm going to cash in. Latches is a doctrine that usually says if you delay too long, even if the statute of limitations hasn't run, that's one thing. But the Supreme Court just this last year decided latches doesn't apply in copyright cases. So that's out the window. Estoppel is a kind of a firmer thing, right? So I told you it's okay for you to do this, and then you do it, and then I come back later and I sue you for it. Estoppel is actually then you're stopped from, you can't bring a claim if you kind of told people it's okay before. Now, there's a kind of little bit of flavor of estoppel here because of the statements that the Sun people had been making, and also Jonathan Schwartz testified at trial that he was fine with Google having implemented the Java APIs. So it may be that the Supreme Court will take a more favorable view about Sun's prior statements, but I'll tell you, it didn't go over with the Federal Circuit at all.
So how does the giant pile of infringers play here? I have an Android phone. Am I infringing?
Yes, right. If Google is an infringer, so is every device maker that has an Android platform. So is everybody who owns a phone. They are equally as much infringers as Google would be because the code's embedded, right?
And does that play on the Supreme Court's mind?
It might. I'm going to raise it in my brief. I just think it's absurd.
This is true of any. I'm sorry.
So there are less than 2 minutes left. So you in the back.
Just following that last question, I would emphasize that the consumer might be guilty of infringement as well. What about the mobile carriers?
They would all be infringers too.
So wouldn't they? Have they filed these briefs or?
No,
or they?
Not yet.
I would suspect that it's Android that they would be very, very.
Well, that'll probably happen at the Supreme Court level. I think they didn't want to weigh in at the Federal Circuit level. I mean, one thing that lawyers know that other people don't is the Federal Circuit doesn't really like amicus curiae briefs, and especially doesn't like them from professors. So I got cited twice for propositions that, in fact, I don't have as my proposition. So it's like very cute.
So a decision for Oracle, how would that affect the Android ecosystem outside of the United States?
Well, so know, copyright laws exist in other countries too, so Oracle could try to take the fight to other countries. You know, I think at some point, if they win before the Supreme Court, which Lord knows I hope they don't, but if they do, I think the case will settle.